Any mention?
Faster, yeah.
Item number 1.
It's 1 and number 2. Only 2. Yes.
Lord, in this case, my lord, before the single bench, we have already filed one written arguments. We are mostly relying on that written argument.
Sen?
My lord, so far before this court we have not made any hearing. My lord.
You filed
It's true, my lord. Even me also I have filed. Now only thing, if I can, my lord, refresh my minds.
Yes.
My lord, they are basically saying about the rimwai, my lord, it should be by a follower of indigenous faith,
Yes.
not by a Christian.
Yes.
And they are basically drawing their entire inspiration, my lord, from that Juai Alaka case, my lord, which decided by Supreme Court. Now there is a clear distinction between the two. So for Juai Alaka is concerned matter, reach Supreme Court, my lord, and it is the District Council, my lord. We, my lord, place the entire record, and we say, my lord, our contention before the Supreme Court, along with the record, that all throughout, my lord, it is this thing, all throughout, my lord, the Doloi belong to indigenous faith. This is supported by the District Council along with the record. Except on 2 occasions, my lord, brief period, 2 Christian Dolois were appointed. Immediately there was a sharp reaction. Supreme Court took note of that and said, at best, this is an aberration. So from the record, it was very clear, all throughout it was held by a person who followed the indigenous faith. Now, my lord, that inspiration cannot be drawn from the situation. Facts are totally different in Rimbai. As per our records and affidavit, my lord, even during the, my lord, time of British Your Lordship, there was a Christian Doloi. Then thereafter, my lord, number of Christian Doloi, my lord, who followed Christian faith, my lord, they completed their entire term. Some of them served till their death. So, my lord, these are clearly at best, my lord, to enforce, my lord, a customary right. Custom should be clear. There should not be any dispute. Here, there are, my lord, serious disputed question of facts.
Have you given your written note?
I have given, my lord, and I have relied on those judgments.
Points were already
Those judgments, my lord, categorically say, my lord, if there is a hesitation, my lord, Reed Court will not get into it. And as per our records, my lord, it is very clear, my lord, a number of Christians, my lord, without any interruption.
In a single bench, when a matter is taken up, we had, because we noted from the records itself produced by you,
Lordship,
by the District Council rather, that inquiry is conducted. That was never, what do you call it, solidified anything. There was no positive or negative.
They own the report, they have not travelled anywhere.
They have not travelled. So perhaps we might look at that aspect. That's the only thing.
Other
There
aspect,
has to be some clarity. There has to be some predictability also, you see.
but that apart, my lord,
We can't leave a certain, we have to weigh all the pros and cons and the consequences, and and also look at the custom, and also that there was an attempt also, and then by this council itself to inquire about the custom, and inquiry was done.
Yes.
And so, but thing is that anyway, we will.
apart from this, your lordship, only thing is apart from this, my lord, they were regular Doloid who followed Christian faith, my lord, and they served till their death, your lordships. There are those instances we have said. So at best, my lord, what it becomes a disputed question of fact, my lord. This is not a custom, my lord, which my lordship can ask for a writ, my lord, for enforcement.
It is not.
And those are number of decisions, my lord. Those decisions are very clear of Supreme Court. A number of decisions I have said.
We are trying to enforce the fundamental rights which was guaranteed. It is not necessary that all religious, my lord, rituals has to be a custom. We are trying to, my lord, enforce the fundamental rights. It is not necessary to be a custom.
Thing is that the basic premise of that case went for the Supreme Court was, what are the functions of Doloi?
Right, my lord.
Whether they can be purely secular,
Yes.
or the administrative, or whether they can be divorced into two.
Yes.
That's the thing. What are the functions of Doloi? Whether in a particular elaka where certain rituals are followed, whether the Doloi has performed them,
Yes.
or it can be performed by someone else, or it's only exclusive to him, and whether those duties which are, would come with the office,
Yes.
whether it can be performed by a person who does not believe, or who does not, subscribe to that faith.
Right, my lord.
So those are the things you have
Yes,
to look
my lord,
at. So that was a consideration.
our
That was
argument, my lord.
other cases from other parts of India also in temples on whether who can occupy,
Yes.
the office.
Right.
So that's what it is not a simple matter.
My lord.
We will weigh all those things.
Yes, my lord. Our argument was, my
So
lord,
the nature of the office.
the
that
duties
we
cannot be
follow.
separated because
Yes,
it
you have
has,
yes. And whether a Doloi who is not willing to perform,
Yes.
the rituals, or whether he's fit to occupy the office,
Occupy
because
those-
by custom,
my lord.
it comes with that
Exactly.
burden.
Those are the questions
Burden or
that has to
duty.
be
I'll say
answered, yes.
duty that a Dalai who comes, who's elected by the people, he has his duty to perform
Right.
to the public, to the eleka rituals, and apart from his secular duties like
Right.
administration
Exactly.
and revenue, whatever.
Yes.
We will weigh that.
My lord. Oblige.
Yes.
Those aspects we have clarified in our affidavit.
Yes, no,
my lord.
we
Who
will do that,
performs,
because
my
that's
lord,
only thing.
what are attached,
Affidavit is
what
already part
are,
of
what are
it.
attached to the office and not.
Yes, I think you have to
Additional copy.
2 copies. You have to supply, please. Yes, please supply copies of the written submissions. Yes, fresh copies. Okay. And you can make. I've read your written argument, the last one.
Yes.
It's very, very long.
Yes, ma'am.
Longer than the petition, I think.
I made it very short,
So,
madam.
so try to make it a little concise, and we'll give you 1 week's time.
My lord.
In 1 week's time, you will post after 1 week. You just file your written submissions, and we will reserve it.
Oblige.
Very good. Yes. Just after 1 week, yes, for filing of notes on submissions.
Item number 2.
Please, Lordship.
Yes. To Milan Gabi.
Lordship,
Yes.
here I am praying for calling of the record, because why the intention, the main grievances the placed by the petitioner here is the private respondent, they have succeeded in the writ petition. The allegation is that statement is on the basis of the enclosing the post document, which they have clearly stated in their affidavit in opposition, and that as per the original document, there are 2 documents which they have enclosed. The private respondent, they have enclosed the genealogy tree, which they have enclosed is the moment. But as per the original record, madam,
There is a 1,645-day delay. Delay has not been condoned.
delay has been condoned, Your Lordship. On the last occasion, Lordship, it says that if the petitioner, the review petitioner, can establish the fact of the case, that it will be looked into that. That observation was there on the last occasion. Of course, that is not reflected in the order.
Yes, no. You have to make out. See, the thing is that law of limitation will not apply to writ proceeding. But a delay, even then, you have to be reasonable. Why you have to come out of 1,645 days? Where's the objection? You filed it.
No, not yet.
Then
That they can still
never
objection
been
to the
condoned.
delay of continuing. They can still.
We filed it, madam. Objection was filed.
it has not been
You
condoned. No, we have to understand that it's a hurdle, which is not a question of long delay. But the thing is that why have you come up to 1,645 days?
I filed it on 27th, 10th, my lord.
Yes, that in this case application. I have stated the reason, Your Lordship. The reason for delay in my miscase application, page 4 to page 4. Then I have stated the ground till page 9, where I have mentioned till point 6. All those ground I have actually mentioned. On the last occasion, Lordship, is that this objection for condemning of delay can be remain open until then. I can argue the main fact of the case. Now here great contention is that I am pressing for recalling of the record because there are 2 documents which they have enclosed. The private respondent, they have enclosed. They are claiming that
our inquiry to how do you explain? We will see you file under, like the objection has said, this is not applicable. This is under Chapter 3, Rule 4 to the Meghalaya High Court rules.
To file it under long provision of law.
That is for an appeal from single bench to a division bench, right?
Yes.
Now, what this court wants to hear from you is, why have you slept over your rights for 1,645 days? It's on reasonableness of your sufficient cause that you should make out as to why You didn't come to court before.
Yeah,
The judgment was passed at the bill. Your party there, correct?
yes, the reason was because the predecessor, my husband, actually my grandfather was the grown-up, was taking care of those cases. But during the pendency of the writ appeal, which is pending before the division bench, he expired his own record, which his name also has been struck down.
Where we said?
Where your lordship is in the writ appeal, my lord, in the page.
Not an appeal. In your application, where we stated that?
Yes, in my application also I have stated that. However, this was in page 5, para 3 also have para 3, that point number 3, subpara 3, I have stated that that appeal was filed by late Gronot M. Sangma and his wife Tunila Gabal Ganget. However, late Gronot Sangma was in constant touch with the previous counsel, but unfortunately, late Gronot M. Sangma expired while the
exact date he died.
Exact date, lordship somewhere I have mentioned, but it is the fact that he died during the pendency of the repetition.
Who was the previous counsel in the matter?
Previous counsel in the matter be reflected in the writ appeal.
You are saying that this Gonat Sangma died during pendency of the appeal.
Yes,
That's the submission.
page 291. 291. Appeal 111111.
Previous counsel was R. Karma.
What?
Saranjit Karma.
Okay.
And it's called it already expired. In the writ appeal is the page number 111. Even the appellant number 1 strike down. They have put it a note also.
Yes, we do one thing, Mr. P.T. Sangma. So, we will take up a review petition for review, and delay and latches will be part of the question to be answered at the time of final hearing.
Lordship.
Yes.
Therefore, I'm pressing that.
This will close this one. As we'll close this one, as you know, as question of delay, we will.
Yes, Lordship.
We'll take this case review. Petition number 10/2025. Stop. This application, having been filed erroneously on assumption that all limitations applicable in writ proceedings is not necessary for consideration, and the same is disposed of. Stop, please. And then the review petition, registry directed to register and diarize the review petition and list for admission after 2 weeks. Yes,
Lordship.
the question of delay and latches will be left open.
In the meantime, case record may be called for you from Lordship.
Yes.
I'm pressing for the calling of the record of the.
It will be in this case. Delay and latches will be open. The question of delay and latches will be left open.
Item 3.
Much better, Lordship.
Lord, in item number 3, I appear the petitioner. It's been 5 months, no reply has been filed. It's the 4th occasion that they have come empty-handed, my lord.
We will safely exclude the winter vacation period, madam. But we will file in the course of the day.
In the course of the day. Mr. Ghosh, this, they will file in the course of the day. You can hear us?
Then, my lord,
Yes.
Lord, may keep it on then 3rd of March.
Yeah, Doctor in Musicology,
I'm fine to
by so and so. After it will be filed in the course of the day. So it's a matter on which
3rd of March. My lord.
He said, all right, 3rd of March.
Yes, my lord.
It's a month.
For rejoinder of any.
That's right. And my lord, may extend the interim order, my lord.
Interim orders of any shall stand extended, yes,
Obliged. Obliged.
until further orders.
Item number 4.
Highly obliged, madam.
This also. Yes.
This is also for affidavit, my lord. I'm praying for.
Your registration has been revived.
Registration is derived, but unfortunately the system is not allowing to file the returns till date.
How?
Because there is an amount of recovery amount 18 lakhs is showing. Unless until that is not removed from the system, it is not allowed. And we have intimated to the department also, the respondent 3 and 4. But they are telling that we are helpless and we are referring the matter to higher authority for necessary rectification of these things.
Yes, Dr. Mojita.
I'll try to instruct them.
So,
Registration has been restored, my lord.
registration
Now-
is restored, but unable to
whether
file
the
anything.
other things are in their hand or not, because it's just today they informed me.
This is dated
112.
112. Yes, is submitted by the learned counsel to petitioner that the registration has been restored, but however,
System is not allowed to file the
system not
returns.
accepting the filing of returns
Yes.
by the petitioner staff.
And the amount of 18 lakhs something is
Not like that. Yes, next paragraph, Dr. N. Mozika produced a communication dated 1/12/2025, showing that as per directions, the GST registration has been restored and made effective from the date of cancellation. Stop. He further praised him to obtain instructions with regard to the submissions made by the learned counsel of petitioner that the systems are accepting the returns. Stop. Just after
A week's time.
at least 1 week, affidavit will be filed in the meanwhile.
Yes, obliged.
Copy of the
For affidavit,
communication.
my lord, I'm praying for little 2 weeks time.
Okay, 2 weeks. For 2 weeks, copy of the communications taken on board and made part of the record.
Hearing. Item number 5.
Well, it's these two writ petitions, well, it's the two connected matters. Item 5 and item 7, Millets. Now,
It will come to our bench.
Millets, these matters, Millets, there's some difficulty before the other bench presided by the Honorable the Chief Justice. Matter has been placed before my lords. This pertains to, Millets, pensionary benefits of these teachers, Millets, retired college teachers. Now, Millets, I'll draw your lordship's attention to one order. The matter had gone before the Honorable Supreme Court, Millets, and thereafter it was remanded. No, where they have said, no?
No, have you notified a pension scheme?
Not yet, Millets. It is stuck at the stage of notification of the scheme.
We will file an affidavit on 27 January 2026. Lordship will just take a lordship
Where's
of
that?
para 3
Why
of
it
my
will not be notified?
lordship. The preliminary draft has been notified, but there is some procedure required.
Well, it's what
We-
has
we have
happened, unfortunately, here is, if my friend just gives me a moment.
Yeah.
Well, it's initially, after Millet's orders were passed by this Honorable Court, well, it's a board of trustees is required to be constituted. The BOT was notified and it was approved by this Honorable Court. Thereafter, Millet's repeated assurances were given by the state, Millet's, that they are working towards Millet's notifying the scheme, whereas the scheme was also prepared. Now, thereafter, Millet's, on,
State Bank, something that.
well, it's all that has been done.
What is that? That is the
Well, it is the financial advisor, portfolio manager.
portfolio manager.
That's been done. Now, they were only required to, Millets, notify the scheme. Now, what they did, Millets, on 4/11/2025, after orders were passed by this Honorable Court, they reconstituted that BOT.
Hmm.
Now, what has happened after reconstitution of that BOT is, Millets, essentially, Millets, it has now, the composition of the BOT has been completely changed. And now, Millets, they have again notified a draft scheme, which is against the, Millets, very ethos of the Act itself. And now they're calling for public objections. So in a sense, Millets, they have taken the step back from what was already done, my lords, way back in 21/7/2025.
I brought on record where you re-notified what is that? Reconstituted
The BOT.
Is it on record?
It's not on record, my lords.
Then how?
No, my lords,
Is that correct?
It is there.
Where's the affidavit?
The earlier affidavit which we have filed,
It is not on affidavit, my lords. It is recorded by this court.
it is
Order?
recorded.
My lords, my lords,
Order, dear.
no, this is the first one. Well, that has not been brought on record, my lords. Order dated 2/9/2025. If your lordships kindly have a look, my lords. Where's the reconstitution? Show me the reconstitution.
Lordship, I may just assess the court. If I can take a lordship to this affidavit filed on 27 January.
If you just give me a second, I'll just bring this order on record. Well, it's 2/9/2025. If my lords kindly have a look.
Yes.
The Board of Trustees for the Centralized Provident Fund Scheme of the State Government has been reconstituted on 21st July 2025. This was the BOT, my lords, that was constituted. It's not reconstituted, it's actually been constituted. And my lords, thereafter they worked and a scheme was already prepared. As a matter of fact, what had happened is, my lords, the state said, my lords, that we are in the process of notifying the scheme. We requested, my lords, that kindly give us a copy. We will give our objections or whatever, my lords, assistance we can give. We gave that. State agreed. This honorable court thereafter records, my lords, that both the parties have agreed to that. I'll take your lordships to that order. Just give me the date of that order, please. Well, if I may draw your lordship's attention to the order dated 6/7/2023. Where they say, which one? The BOT. Where's the BOT? 6/7/2023, my lords.
There's no order 6/7/2023.
My lords,
6/9/2023 is there.
my lords, it's 6/7/2023, my lords, and WPC number 281 of 2017.
Okay, 1 second. I don't have history. Where's the order?
Where is that order?
Where's what is?
Where's the order sheet?
This is the entire order
This
sheet.
is not the order sheet. That's what the Supreme Court orders,
31/5.
where the state says that they're going to do it.
6/9.
Well, as the orders were originally being passed in WPC number 281 of 17.
Yes, 81/17.
If I may first draw your lordship's attention then to order dated 22/3/2023.
Okay.
My lords have that.
Yes.
Well, it's some middle ground may have already been found, and the state submits that it is in the process of preparing a scheme which would be acceptable to the petitioner association. On behalf of the association, it is submitted that the notification of any scheme would by itself cover sufficient ground, but major issue will even be that teachers who have been in service for long may lose out. The association suggests that if a draft scheme is prepared by the state and forwarded to the association may put its inputs which may be acceptable to the state. So that was done, my lords. Next page, my lords, if your lordship kindly see this, since the state readily accepts this suggestion, the state is requested to ensure that the draft scheme is made over to the advocate for the petitioner within 4 weeks from date, whereupon the inputs from the association should be communicated to the state to the office of the learned advocate general within 4 weeks thereafter. That was done. Thereafter, my lords, the next order, 31/5/2023.
Once on 19/6/2023 at around 31/5. For 6/9/2023.
This is the affidavit we have. Next affidavit.
Subsequent one. Where is the first beauty?
29. That is notified by Counsel. Where are the other two? What the hell here? 1906.
My lords have the order.
5. 6, 9. I think that one. 6, 9. 6, 7. That is what we did. 9 comes here. Yes.
My lords have the order.
Yes, I know we've seen the 2-9. Yes, yes, the fourth paragraph.
My lords of.
It's a positive direction.
My lords.
Yes.
Thereafter, my lords, the order matter again came up on 31/5. If my lords kindly have the order of 31/5/2023.
Yes.
My lords, page 2. Accordingly, the employees are required to so and so. A second more important notification has been issued on 29th May 2023 pertaining to non-government school and college employees appointed to sanction posts who joined regular service prior to April 1, 2010. The writ petitioner says that the second notification covers the area of dispute involved in these proceedings. Since copies of such notifications have been made over to so and so, let the matter appear a fortnight. In the meantime, if the association has suggestions, the same may be directly communicated to the Secretary Education Department. We did that again, my lords. And thereafter, my lords, the order of 6/7/2023 comes to be passed. If my lords kindly have a look at 6/7/2023.
6/9/23.
6/7, my lords. 6th of July 2023.
I think
Well, we'll prepare a compilation of the orders and file it. I think there's some. Well, I was having the same difficulty because there were 2-3 connected matters, so some orders here, some orders there.
post after 1 week, yes.
The orders are not
On the request of the party.
We'll prepare a compilation of the important
orders,
orders.
effective orders, and then,
Yes.
yes. Otherwise it's just flipping back and forth. And
It becomes difficult, Millets, and I'll also try and prepare a small chart that will
we have
assist
to
this.
coordinate our minds and not me the details.
Lordship, there is a reason I was relying on an affidavit of state on 27 January. Because if we turn the clock back, Your Lordship, from 2023 till 8/12/2025, series of order passed. Now after that, we have come to a point where only the draft notification has been finalized. What we're seeking is an opinion and public opinion on that. And for that, we were requesting that the
Is
affidavit
it a mandatory requirement that you seek public opinion?
Lordship, as per the procedure, it's
As a
required.
matter of fact, there is a
they agreed-
positive direction that they were required to
We notified
publish
by 20th November 2025.
25. Millets, we are standing in February. Neither have they sought extension, Millets, and then they are coming and saying that we are calling for objections.
Lordship will kindly see the last order of 8/12/2025.
We don't see any orders now because it's too confusing, flipping back and forth.
Next week, Millets.
After 1 week, yes, you file your affidavit, whatever necessary, we'll take it up.
Millets.
Okay.
I request the party is after 1 week.
Millets, item 7 is connected to item 5.
This item 7 is together with so and so.
7, 8 chip may have a different, it's not similarly situated.
Then why was it the submission made before
That is
the
the submission.
justice? Who made the
Because
submission?
in this matter, Millets, as I pointed out, a submission was made that it is also covering, Millets, deficit school teachers. 7 deals with deficit school teachers.
Because
The
in
scheme
the
How
past
was
case,
college
Lordship,
teachers?
these
How
are
was the teachers?
Under the Act, Millets, the scheme is now covering both, Millets, the
The
college
scheme is to be
teachers,
notified.
Millets. The draft scheme actually mentioned the college school teachers as well. Your Lordship may examine it, Millets. If your Lordships then feel that it is separate, Millets, we'll say.
Lordship, yes.
Yes.
Item number 6.
Highly apply. Highly apply.
No punch on the sheet. No punch. Huh? Huh?
You do it today?
Yes, Lordship.
He's still
Lordship,
ill.
may please, Lordship, if Lordship recollects, in sometime last year we've already advanced arguments with respect to this matter. Also, now the District Council was supposed to advance their arguments. They have even filed their affidavit, bringing on record that letter, Lordship, which was
never placed. Was never placed before the council.
was never placed before the committee.
for the amendment.
Yes, Lordship. So by passing the procedure, Lordship, they have.
Where Mr. Changariso?
He's coming, Lordship.
Yes, he said he's not well.
Lordship, he's returned back. yesterday and Lordship is coming.
May I pray your lordships have it after a week? I'll also need to have a little bit of preparation. I have quite a bit of answering.
Yes. It's on the pre-optional council. You're appearing for the council. The council appearing for the KHDC. Just a matter of 1 week. Yes, only one point was there because it has to be placed with the council. Now the submission was that it was done at executive level only, sent back, and the amendment was passed.
Exactly.
So whether that will be,
I'll have to satisfy your lordship whether it will be a mandatory requirement for the floor of the house.
It's a small thing. Not small thing means that's the only point.
Legally.
How long?
Any mention?
Please, Lordship. I'd like to mention for listing of a matter tomorrow, Lordship. This matter pertains to acquisition of land by NHAI.
Why tomorrow?
Lordship, some urgency is there. Only grievance, Lordship, is that I had placed certain objections for not disbursing the money to certain landowners. There's some discrepancy.
But why? It's only pending.
No, Lordship. Fresh matter, Lordship.
Tomorrow's Friday.
Friday, Lordship.
Okay. Yes.
Your Lordship, I beg to mention item number 26. Mr. Philemon Nongbre, he had to leave because of personal emergency, Your Lordship.
It's not here, so.
He'll inform you.
Nongbre is not here, so.
He was here in the morning.
He was
Yes,
here.
sir, but he had to leave because of emergency. Yes, Your Honor.
Yes. When? Tomorrow? 1 week, okay.
1 week.
Much obliged, Your Honor.
Please, Lordship. Lordship, I beg to mention item number 20.
You have put an application?
Yes, Lordship.
What's the reason?
The conductor counsel is out of station, Your Lordship.
Are you still? This. You're there, Mr. Paul.
No.
This court getting fatigue of these election matters.
I-
If you are
I
serious
hope so.
about, if you're serious about pursuing it, please do it. Otherwise, nothing will have to. You can't just waste judicial time. Yes.
Completely unsigned and
No, that is fine, but then like, at least the matter should be taken up.
yes, my lords. Yes, my lords.
Who's the lead counsel here?
35 or
So SDEP, Your Lordship. SDEP.
Where's the SDEB?
He's out of station, Your Lordship.
What the order is? What did like you? Yes.
Lordship, I beg to mention item 23.
Who's there?
I'm there, Your Lordship, for discussion.
Your objection?
No, Your Lordship.
Okay.
After 3 weeks. Obliged, Your Lordship.
Please, Your Lordship.
Well, it's item number 17, Millets, of the list. This is that Millets freight matter.
Which matter?
Freight Millets, transportation freight matter, my lords would recollect. Regarding Millets, the rates that were notified by the state, Millets, and your lordships were pleased to take up the matter.
Right,
We
right.
filed a miscellaneous application, Millets. I'm just praying if that miscellaneous application is also taken on record. Millets. It's not come. It's filed yesterday, Millets, copy served.
Copy, sir.
Yeah, Lordship,
What's
we
it
got
about?
Obliged.
Call for the this case.
Supplementary 1.
May it please, Your Lordship.
What is this?
Fresh state petition, my lord. Petitioners are aggrieved, my lord, by the arbitrary, sudden, my lord, and abrupt blockage of two medians, my lord.
Medians?
Yes, my lord. On NH 27 in Reboy district. These have been, my lord, operational since the year 2010. Sanctioned by the NHAI. Now, my lord, respondent number 3 has suddenly, my lord, on the 20th of January.
3 is whom?
My lord,
Assam.
Assam. They have shut it down. Now, my lord, what I have been instructed is, my lord, day before yesterday, these have been reopened. However, my lord, it is our anxiety, my lord, that they will do the same thing again, my lord, and close it down.
You mean in the highway?
Just outside the CRPF building, my lord, there are two chainages, my lord. Gate number 1 and gate number 2 of the CRPF building. Those two, my lord, have been sanctioned. If your lordships have my IA, my lord, sanctioned in the year 2010.
Yes, and what happened?
And my lord, now on the 20th,
When will they close?
We don't know, my lord. All of a sudden, my lord, on the 20th of January, they've been shut down, and two further signages, medians have been opened, my lord. Further.
Now they reopened.
Yes, day before yesterday, after the filing of the petition and service of the petition.
Then
let status quo be maintained, my lord. Let them not be shut down again. In my IA, my lord, I have placed on record, my lord, the sanction letter, my lord, of the NHAI.
278.
Now, this is miscellaneous case 8 of 26. And my lord, in the IA, Lordships will have, my lord, page 13, by letter of 29th of November 2010. Lordships have that, my lord? This is NHAI's letter, my lord. Your Lordship kindly has paragraph 2. Matter has been reviewed by the team leader and the team leader has recommended for shifting of the nearby median opening in between chainage 167,598 to chainage 167,623, that is gate number 2, for a width of 25 meters.
Right.
Opening in front of gate number 1 has already been recommended with a letter dated 13th of August 2010. Now, my lord, this status quo prevailed up till, my lord, 20th of January 2026, when it was shut down. And, my lord, the Google map that I placed, my lord, is, my lord, on the next page, overleaf. Just to give your Lordships a pictorial, my lord, idea. On the left, my lord, Lordships will find we've highlighted the two cuts, my lord, legal median cut 1 and legal median cut 2, my lord. These were, my lord, the ones that were closed.
So effectively, what they did was they just
shifted it.
Shifted the.
That's right, my lord.
Yes.
That's right. So, and now, my lord, as a result of this, it leads to a detour of about 6 kilometers one way. 2, my lord, unnecessary harassment, my lord, to the local population.
So they're appearing for the respondents.
Lordship, I am appearing for respondent number 278.
1 second. Respondent number
278, your Lordship.
2, 7 and 8.
Lordship, yes.
And MS Merchant. Yes, your name, please.
Gautam Narayan, my lord.
Heard Mr. So-and-so Senior Counsel with so-and-so. You just give your appearances.
Please, ma'am.
Yes, issue notice. Mr. Andy Shrilan, AG with so-and-so is present on behalf of respondents
278, your lord.
7 and 8. And MS Mircham is present, Vice Dr. N. Mozika, DSGI, is present on behalf of respondent number 1. As such, no further notice to these respondents. Notice to issue the remaining respondents within 3 days. Stuff is submitted by the Senior Counsel that the petition directed against the alleged illegal closure of 2 median openings and access points on National Highway 27, Khanapara, Tajorabad, without determination by the competent authority, that is the National Highways Authority. He, however, submits that he is informed
that has been reopened. Yes,
that the same has been reopened. At this juncture, he only prays that status quo will be maintained until the next date. So, Mr. Shula, anything to say?
Lordship, I am supporting the petition.
AAG has no submissions and, in fact, has concurred to submissions made by the Senior Counsel. This is the matter thereof. Let status quo be maintained until the next date with regard to the medians in question. List after 2 weeks, Your Lordship. 2 weeks for the orders and for. Yes.
Obliged. So deeply obliged, ma'am. Grateful.
Item number 2.
If you may please, Your Lordship, the leading and conducting counsel in this matter is Mr. P. Nongbri. So I'm praying if the matter can be listed before different bench.
It has to be done by Mr. P. Nongbri only, not by you.
No, Your Lordship.
Why?
I'll have instruction in the matter.
Exclusive brief.
Your
Yes,
Lordship.
this is, MST Sutanga submits that. Yes, okay. This is a matter before any other bench without me.
3.
May I please, Your Lordship?
Yeah.
Your Lordship, this matter pertains to freezing of account by the respondent.
Not a freezing case.
Yes, Your Lordship.
When was it frozen?
Your Lordship, somewhere in the last year, somewhere in the month of October 2025, he came to know that his account has been frozen, Your Lordship, without any prior notice or proper reason, Your Lordship. So the petitioner, he immediately rushed to
when
the
is it
bank.
frozen?
October last year, Your Lordship.
That's October?
Yes, Your Lordship. And he immediately rushed to the bank, Your Lordship, for inquiry. But then, upon seeing no positive response,
Which bank is HDFC?
HDFC.
Why all these cases only HDFC bank only? Who was the counsel appear in HDFC? Who's appear? How to catch Mr. Marpan? Because all the cases that are coming is only It's only HDFC, yes. And after you served them notice also, they've not done anything?
No response, Your Lordship.
Since November?
Yes, Your Lordship.
You
And
wrote
then
ombudsman also, nothing?
you know, Your Lordship.
Yes, heard MSH Garcia. Issue notice, Mr. H. Abraham.
1 and 3, Your Lordship.
NG is present, except we have 1 and 3 notice to issue to the respondent number 2 within 3 days. It appears this is another matter concerning the freezing of accounts by the concerned bank. In the instant case, it submitted by the counsel that in spite of legal notice dated 21
November
11 2025 and also an application before the banking ombudsman OMBUD SMAN, the petitioner has not been afforded with any information or reason as to why his or her his account has been frozen since October 2025. Just after 1 week or 2 weeks? 2 weeks. Yes.
Daily list item number 1.
Your Lordship, I pray for some time in this, Your Lordship. My senior counsel, Your Lordship, due to a minor accident, Your Lordship, is unable to attend the court.
An accident?
Yes, Your Lordship, she fell down, Your Lordship.
Oh, fell down?
Yes, Your Lordship.
Oh, she's alright?
She's okay, Your Lordship, but she's unable to walk and sit up, Your Lordship.
Oh. What to do?
Oh, no objection.
After 3 weeks?
3 weeks, Your Lordship. Similar prayer for item number 2, Your
Mr. Vanswet. Then it transfer the responsibility due to the as the senior counsel has suffered an accident, the matter be adjourned for 3 weeks. Praise allowed, yes. Similar, are they the appellant in the other case?
The other case, I'm the appellant.
You are the
item number 2, under item number 1, I'm the respondent. Item
number 2 is a appellant. Against the same award.
Same award. Oblige.
3.
Please, Lordship.
What's the matter today?
Lordship, the draft of the rejoinder is ready, but only the signature.
Filing rejoinder is closed.
Lordship,
last chance has no meaning, yes.
Please grant us for the 1 week, Lordship.
No. Though a plea has been made by MS Itakhat that the rejoinder is ready to be filed in the course of the day. No,
Lordship, after 1 week, Lordship.
After
1 week, Lordship.
The draft rejoinder is ready. Approval of the order dated 10/12/2025 would reflect that last opportunity was granted. As such, filing of rejoinder by the petition is closed. This is the matter for
hearing.
This for admission hearing. Admission hearing next date, yes.
Oblige. 3 and 4, my lord, connected matters. 3 and 4 both are connected matters.
You tell Mr. Deb. Not your fault.
5. Madam Lords, the steps were taken for the service of respondent number 2, my lords. And the respondent number 1 was directed to file the reply, my lords. Till date, we have not received any reply.
Here for 1?
Yeah, for 1, Your Lordship.
Where's the reply?
I'm seeking time, Your Lordship.
In the course of the day?
No, Your Lordship. 2 weeks time, Your Lordship.
In the?
2 weeks time.
When was the matter filed? Notice, see, notice to respond number 2 is returned unserved. Who's the local counsel? You don't have a local counsel?
I do have a local counsel.
Where's the local counsel?
He's unwell today, so he's unable to appear. Mr. Chandran Deka. I'll request for issuance of
fresh summons. Yes. Office note indicates that notice issued to respond number 2 is returned unserved. So petition to take fresh steps upon respond number 2. personal service also permitted. Stop. Next paragraph, MS Sun for the learned, for the participant number 1. Pray for further 2 weeks time to file affidavit. Just out of 2 weeks, yes.
Delibulation.
6.
May I please, Lordship?
May I please, Lordship? We're praying for some more time for compliance, Lordship.
But it's only compliant, you said last time?
My Lord.
Lordship is still under
My
consideration.
Lord, 4th November order is quite clear, my Lord.
What's 4th November say?
My Lord, I directed that before the next date, the compliance order should be before this honorable court, my Lord.
Yes, it's clear. This clear contempt then.
Lordship is still in the process, Lordship.
Process of
Compliance, Lordship.
why is taking time?
Lordship, we've been told that there it has to go through many procedures, Lordship. So it.
Where's the
takes some
procedure?
time.
Where's the affidavit then?
Lordship.
Disability pension.
My Lord.
Last was already 10/12.
Praying for 2 weeks' time, Lordship. We'll positively bring some
compliance.
instructions, Lordship.
For compliance, positively.
Lordship, I'm not sure. We can.
Where Dr. Muzika? What's about the time being? Let him come. Yes.
7.
May please, Your Lordship. Your Lordship, the respondents are supposed to file their affidavit, Your Lordship.
Your Lordship, you may be given 2 weeks time to file affidavit, Your Lordship.
Why didn't appear last time?
There was little miscommunication between this Simo Bhattacharya and myself, so
Mobile?
it was actually handled by this S. Bhattacharya, Your Lordship. So at least I'm taking care of the matter, Your Lordship.
You have not joined work?
Not yet, Your Lordship.
Yes.
I've sent for signatures.
You already filed?
No, Lordship. I've sent for signatures.
Yes, Mr. H. Abraham 123 at MSB Pasar 04. Pray for and allowed further.
Next time, Your
2
Lordship.
weeks time to find.
Hello. Hello, Your Lordship.
8.
My lord, I'll need a little time, my lord, to file my affidavit. I sought for clear instructions. I'm just waiting for them, my lord.
Pension matter?
Yes, Your Lordship. Yes, my lord.
Which department?
PHE, my lord.
Then we don't allow delay.
I will not delay, my lord. It's just a little clarification that is needed.
Calculation?
Clarification, my lord. There's certain points which were not tallying. That's the reason, my lord, I had asked for them to rephrase.
When he retired? On 22, okay. Yes, you filed positively. MS
Yes, my lord.
UI Bank for response number GA4 127.
Yes, my lord.
And EB Pasa, you filed?
No, Lordship. I've sent for signatures for same, Lordship.
Yes, and for sponsor pray for allowed for a 2 weeks time to file affidavit. Expected next date, they should be on board. Yes.
9.
Please, Your Lordship. I'm praying for some more time, Lordship, to
Affidavit,
file
my
our
lord.
affidavit.
This is a recruitment, my lord. Selection to the post of radio mechanic, my lord.
Why come by it? Why you not selected?
My lord, I have been selected. It was I was not allowed to join, my lord.
Why?
My lord, I was a rifleman cook and then competed for the rifleman radio mechanic, my lord. Thereafter, I have to resign that, and in that process, it took time, and they could not allow
You're
me
serving
to.
rifleman cook now.
No, my lord.
You lost the job also.
On their instances. So affidavit is.
File affidavit, yes.
My lord.
As paid for a 2 weeks time of affidavit. Yes, thereafter. This also.
Hello.
10.
Then 11, 12 and 13 are connected matters, Your Lordship. We have filed an affidavit.
His Lordship, I pray to file a short reply to the rejoinder. This is regarding
taking
the
over regularization of the non-teaching
regularization and
staff.
payment of salary. So,
Of non-teaching staff?
Lordship.
Who were of those
Okay.
Garo Hills Autonomous District Council
What is the
schools.
judgment in this matter?
Yes, Lordship, but they're saying that I am not qualified. So I will file a short reply to their file a rejoinder, small rejoinder to their affidavit. Then
All the cases similar or separate?
they're all similar. All similar.
All similar?
Or all non-teaching
Distinguishable,
staff.
Your Lordship, because they have do not have the qualified years of service, Your Lordship.
There is polling of sort some 2-3 months like that actually supposed to be us on the.
You ought to have qualified
five
years
but,
of 5 years.
But on the
in
earlier occasion,
94.
some
before 94.
Yes, but this man, the first petitioner, was appointed only in 96. So he doesn't have the qualifying number
in
of
some
years.
cases, Lordship have given them some consideration.
No, give consideration to people who are in service, non-teaching staff. When that act came over, taking over primary education by the state government, obviously council schools, before it covered only the teachers, correct?
No,
Yes, Your
Lordship,
Lordship.
not
And after that, even the
Non-teaching staff.
who at certain time were, I think, out of the court also, then they have been considered to be government employees. Now, you don't come within that definition.
No, Lordship,
of
even
working at a point of time when the
Act came into existence,
Yes.
Your Lordship.
Lordship
when the act
on,
came to being,
on the earlier Lordship, even the non-teaching staff who are not completely, maybe 2-3 months was left actually, but then they will consider, Your Lordship. Therefore,
in this
I
case, it is
maybe
not a-
just given a short time, I'll file a rejoinder that it can be, matter can be here at length, Your Lordship.
Okay. MS Yangi B Line AG submitted the affidavit has been filed in this matter and other connected matters. Stop. Mr. PT Sama, please went out to file rejoinder affidavit.
Lordship.
Just after 2 weeks, yes.
Lordship.
Pleasure, Lordship.
2 weeks,
10
can
to-
file it 2 weeks?
Yes, 10 to 13, my Lord.
Yes, 10 to 13, same order.
14.
Most blessed, Lordship.
Hey, please, my lord. My lord, in this case, my lord, I have an issue notice because they have removed me also from the post of acting Sardar, my lord. So I don't know whether I'll proceed. Whether I'll
Who has
proceed,
removed his aim?
my lord.
You filed a petition also? No.
No, my lord. So I don't know whether to proceed or I don't have any instruction.
You wait us.
My lord.
Fair submission, yes. Mr. Singh submits that the petitioner approached this court in the capacity of you were full Sardar.
I'm the acting Sardar.
That time?
Acting Sardar.
In the capacity of active Sardar of Walang Khandai Kantoj, non-spokes aimship, has also since been replaced. There's not an active
If I'm
Sardar
not,
now.
if I'm not mistaken, by the month of December,
No, replaced by whom? Another person.
my lord.
Replaced by another acting Sardar. He's therefore submits that the matter will be after 3 weeks enable him to obtain positive instruction.
That will be 4 weeks, my lord.
3 weeks enough.
Okay. Hello, Blashman.
15.
Yes, after 3 weeks, yes.
Here in this case, Your Lordship, we pray for 2 weeks' time to file affidavit.
No objection.
Yes, as prayed for the 2 weeks time allowed for affidavit by the state respondents. No other respondents.
No.
Okay.
16.
Respondents have to file affidavit, Your Lordship.
Who has filed?
No one has filed yet.
No one has filed.
Lordship, for the state, I need some more time, Your Lordship.
What about district council who's appearing?
Mr. D.
Where's Mr. D? He's outside.
I'll need some time, Your Lordship, to have the instruction.
What about Consul? They're being paid.
I do not know, Your Lordship. Mr. Bingo will be in a better position to.
These ex-MDs are being paid regular pension in Consul's council.
They are being paid, my lord, but the areas are there. In fact, the district council is going to repeal. They place a bill for repealing the act.
So it might have a cascading effect on your case also. Yes, Mr. Andy, should I lend it? We have respondents
1 and 2, Your Lordship.
1 and 2, and MS Idahar for 4 and 5. Or for MSE was up for 4, for 5. Oh, yeah, 3. He was up for 3, and he have 4 and 5 pre-follow for a 2 stand of 5. Affidavit. This is the last one also.
Outline.
17.
Modify.
And may it please your lordship, my lord.
Yes.
My lord, if your lordships, my lord, take your lordship's last order of 7th of December. My lord, your
7th of
lordship had
December.
kept, my lord. 17th of
17th
December.
of December.
Yes.
My lord, your lordship has been pleased to keep in abeyance, my lord, the notification of 2025.
Yes.
My lord, because, my lord, your lordships, my lord, were of the view, my lord, that after the amendment to, my lord, section 67 of the Motor Vehicles Act, my
Yes.
lord, the state did not have, my lord, any power to, my lord, fix rates.
Yes.
So, my lord, now, my lord, if your lordship, my lord, come to paragraph 7, my
Yes.
lord, of the order, my lord, your lordship directed, my lord, that, my lord, since an earlier rate had been fixed, my lord, on 28 November 2025,
Yes.
my lord, at ₹7, my lord, per metric ton per kilometer.
Yes.
My lord, your lordship, my lord, provided for, my lord, it to be, my lord, ₹8 per metric ton per kilometer.
Yes.
My lord, so that, my lord, there was no possibility of cartelization.
Yes.
Now, my lord, we have filed an application, my lord, to indicate that as far as, my lord, the cement manufacturers are concerned, my lord, there is, my lord, no question of, my lord, cartelization. And, my lord, this amendment really was, my lord, to let, my lord, market forces, my lord, determine the freight rate. So we've sought a slight modification, my lord, of your lordship's order.
Have you filed
My lord,
affidavit?
if your lordship,
Lordship, so far this state, I have not filed affidavit, Lordship. I have instruction. I would like to put by an affidavit, Your Lordship.
You put an affidavit.
Lordship.
Then we can dispose of the entire matter to
Lordship,
this
yes.
case also.
yes, my lord.
Next date.
Yes, my lord.
After 2 weeks, Your Lordship.
Well, so far as service of the private respondents are concerned, we've seen, in effect, all the associations have been served. Some through the associations, some through the president's and secretary.
So service is complete.
Well, I'm appearing for respondent 14, 15 and 16.
Show the writ. 15 and 16. That in effect, I think, have service on 14 as well. 14, 15 and 16 are the president secretary of.
I'm representing, my lord, respondent number 14, 15 and 16.
Okay. What about other respondents?
In so far as service on 6 is served, 6 is served, 7 is served, 8 is served, 9 and 10 are the president secretary of 8, so essentially served,
Yes.
11 is served.
Yes. 12.
12, 13 are again president secretary of 11 minutes, so they would be served.
Oh, yes.
14, 15, 16, of course, they have entered appearance.
Yes. First taken in this case. This case 10/2026 is an application for modification of the order dated 17/12/2025 passed by this court in the main petition of the prayer modification order is any case. Next parameters, any should I submits that as the I get to file affidavit in the main case. You're permitted to file an affidavit in the main case, which will also answer the prayer made in the Mrs. application, Lordship. Top, this is a matter we listed for admission hearing.
Lordship.
This
Disposal
also
at the stage of
that
admission.
The notice is complete and all correspondence.
My lord, with your permission, my lord.
And Mr. J. Shilla has entered appearance. We have 14, 15, 16 who prays for. You want to file affidavit?
Yes, my lord.
Who prays for? And okay, we'll give 2 weeks time to file affidavit. Yes.
Lordship.
It's a matter of 2 weeks of further orders. In term orders to continue.
Apply, Lordship.
Great, my lord.
Great.
18.
My lord, this matter, my lord, pertains to the removal of the headman, my lord, of Kundong Walang, Himanuspung. I have served notice to respondent number 4, 5 and 6, whereas respondent number 7, he don't want to accept the notice.
In this case, my lord, if your lordship will come to page 29.
4 and 5, okay, will you report first?
Yes.
What about 6 and 7?
7, he don't want to receive, my lord. In fact, I went and approached to
Personally?
My lord.
And then what did he say?
He said, I
Take it back.
No, I don't want to take.
I don't want to take. You consider himself then, yes.
Anyway, my lord, page 29 of the petition, this is an appeal filed before the executive member against the order of the
CM.
Of the CM.
Yes.
Now the district council, my lord, as per my instructions, are taking active consideration regarding this, because my lord will see.
The one thing you want to know whether there was any complaint against him.
Complaints are there, my
He
lord.
was elected for a term of 3 years.
No, my lord, that is questionable also. Now, Annexure 2 was issued by the then acting CM. This will be on 26th August 2025.
Yes.
Now, as per the report received by the council, there was an election held in the month of January and a new headman has been elected. Now, Lord, we'll see, we have certain documents here which shows that as on 16/10/25, on 10 September 2025, the petitioner has acted as an acting Rangbashnam, not as a full-fledged headman also. We have documents.
If it is in that way, my lord.
That is why we want to have a full-fledged inquiry, the executive committee. So the matter be remanded to the executive committee and we'll look into all aspects.
My lord, if I may below, can you take to Annexure 2 as well, which is page 20, my lord, of the my translated.
Yes.
To Shri So-and-so, my lord, village Kundong Walang, that as per the memorandum presented by the village Kundong Walang, dated 20 August 2025, sent to the office of Himanuspung, and the same has been clearly pointed out and confirm you as the Rangbashnam of the Kundong Walang Nongspung CM-ship. Today I am pleased to confirm you as the full-fledged Rangbashnam.
Okay.
Can you come to page?
We have documents to show that
my lord,
on November and October, he has issued certificates as acting Rangbashnam.
That is on which date?
One of them is on 16/10/25, then 10 September 25.
Then how comes 26 August he already confirmed as full-fledged? You signed documents on the days acting.
No, carrying with that. My lord, can you come to page 21, my lord? The last paragraph, my lord.
You do not question the veracity of this document 26. It is issued by the acting CM. Correct.
Issued, but under what capacity, whether it was done in the proper manner. That's why, my lord, we need to have a full-fledged inquiry by the executive committee.
My lord, can you come to
page? Certain whether this was really.
Yeah, Shalla, what are you saying? It's not by the acting CM.
Yes.
Yes.
If my lord will see in Annexure 3, it's clearly when we remove him, my lord, we clearly mentioned there that he's an acting Rangbashnam, my lord.
In fact, my lord,
people are coming to us with allegation, my lord, that they have forged the signature, my lord. That Annexure 1 also, those signatories in Annexure 1, the signature has been forged, my lord. In fact, he is just an acting, my lord, and he has been removed. So this, my lord, since
So
we
you
have
mean he
submitted
confirmed himself by forging signatures of the acting CM?
My lord, but the Sanat has a full pleasure.
Are you appearing the acting CM? Mr. Shilla, you're appearing
Yes,
for
my lord, Annexure. For acting CM, my lord. Respondent number 4.
My lord.
Now you say that you never signed. You say you never signed that, or he was the early acting CM.
I was the earlier.
That's the problem.
But on the
This matter needs
26 August 2025, my lord.
Take down.
It has to be inquired by the executive committee.
You send it back. Let them.
Yes.
You can adduce evidence if you want also.
But the people already are totally confused, my lord. Let the impugn order Annexure 3 be stay, my lord. Till they
Who's
find.
looking after the administration now?
The new headman, because my lord, as per the report which we have received, there was an election held also.
To avoid the confusion, my
Yes,
lord.
my lord, election have.
Annexure 3, my lord, if I may be allowed to read.
Confusion, Mr. Kharshi.
Yes.
Suppose if we status quo ante,
Yes.
it's like we can't allow that.
On 21/1.
Are you aware of this?
No.
No.
A public notification was made, my lord, for election, and they didn't even come and participate, my lord.
Who the petition?
I have no knowledge regarding with that also, my lord.
Yes, my lord.
You stay in the same village.
It's a
My lord.
public-
I have no notice.
My lord.
I have no idea. that
No,
people are
nothing, my
voting.
lord. My lord, nothing, my lord.
You're sitting inside a house, thinking you're still headman.
My lord.
Then
In fact, my lord, Annexure 2, page 21, my lord, the last portion, if I may be allowed to point it out, my lord.
1 second.
Item number
21:1. We can't decide this matter here,
Yes.
Mr. Kharshi.
There has to be
I may
Because
be
there are
allowed.
too many claims, counter claims. If there's a question of forgery or fabrication, then you have to file FIRs also. You take down then, yes.
I have no issue, my lord, if the instant matter was transferred to the
But we
respondent
can't allow you
KHDC.
to resume
But
office
my lord,
right now.
but my lord, to avoid confusion, my lord.
See, the thing is
Can
that
you
if
state
it's
this?
very clear that arbitrarily you've been removed, there is a confirmation. There's a confirmed bad action scheme in your favor, and that somehow without it proceeding a procedure you've been removed. Yes, we can understand. But in this case, if they even question the very fact that whether it was signed at all by the acting aim, whether the
My lord,
members
by the Sanat itself, it's clearly.
Sanat this question.
My lord, if the last portion, my lord.
Who was the earliest acting aim?
one Kintiu Borlang Simile.
You have to call him also and inquire.
Yes. That's what we intend to do, madam.
My lord, the last portion of the page 21, my lord, if I'm able, of the Annexure 2.
No, that we will not place reliance on Mr. Kharshi, because we've seen that
this order will effective from today, the 26th August, and it will be expired to 26th August 2028. My term has not been completed.
we understand
there
that,
is
but
no complaint, my lord.
the authenticity of this document also is under question. You have to call this Kintiu Borlang Simle. Yes, we put under examination. Yes, then have evidence whether on that date, 26 August, it issued this to you or not. Then you have to go and do that, whether there was an election, whether you confirm as a headman. If that process is over, then you might be reinstated.
And if he was the headman also, my lord, why should he be issuing certificates as acting ambassador?
My lord,
2 months after that.
a unanimous decision.
These are
Yes, that means you were confused also, you didn't know.
Yes.
A unanimous decision was taken by the people of Kunawang. This is Annexure 1, my lord, if I may be allowed.
We're not going to go there, Mr. Kharshi.
When Annexure 1 people are disputing, my lord, that they have signed that.
If I may be allowed, page 16, my lord.
No, we've seen this.
My lord.
We've seen this. Yes.
So I have no issue, my lord, if the case transferred to district. But can we still, for a time period till complete investigation by the respondent to KHADC, my lord?
I heard Mr. K. Kharshi and Counsel Petitioner, Mr. J. Shilla, has an appearance on behalf of the respondents. 4, 5, 4 and 5. Stop.
4 and 5, my lord.
4 and 5. It is submitted by Learned Counsel petitioner that though notice was sought to be served on respondent number 7, who is the present acting headman, the same was refused. Mr. T.T. Dingdor Counsel is present on the behalf of the District Council of the respondent 1, 2 and 3 have at the outset submitted that the matter regarding the office of headman of Kundong Walang, Nongpung's aimship, is under active consideration, as there appears to be a lot of claims and counterclaims. The same was also endorsed. This the submission was endorsed by Mr. J. Shilla, who has submitted that even the Sanad dated 26 August 2025, which it is stated has been issued by the early acting CM, is also under question. So, next by Mr. K.S. Karsi, however, submits that the petitioner has been duly elected by the village itself, and for a term of 3 years. 3 years.
My lord.
For 3 years, which is expired to 28, and that without
and then duly authorized by the
without any reason he has been removed, and he has been removed for reasons not known. He therefore prays that though he therefore submits that though he has no objection if the matter is remanded to be adjudicated by the executive committee of the council, however he prays that he may be allowed to continue as the duly elected headman of Kundong Walang until further orders.
And they say to be stayed, my lord, the impugned order to be.
That's what he's saying. Orders, and that the impugned order of removal be set aside and quashed. Yes. I've heard learned counsel with the parties and also examine the materials as placed up. Yeah, reference 29, correct? As submitted by Mr. T.T. Dingdo, this complaint is by how many people? Is by
more than 80 people, my lord, duly signed as per the annexures.
More than 80 people. And the people elected you, how many?
Annex 1, my lord. $101, my lord.
101?
My lord.
Okay, then good. If you go for elections again, maybe you might win. Yes.
My lord, even that signature also it's disputed, my lord. Do we have representation before us that the signature is forged, my lord? That
Okay, that we'll leave aside. Oh no, as there are claims and counterclaims, it is necessary for the respondent number 2, number 2,
yes,
to have an in-depth inquiry as to the into the matter, so as to ascertain the correct position. This court's in agreement with the submission of the Learned Senior Counsel, as much as many disputed facts have been brought into play, such as whether there was any election for the post acting headman, whether the sanad was issued by the early acting chief, and whether there were any effective complaints against the writ petitioner. In this view of the matter, next paragraph, the matter shall stand remanded to the respondent number 2, who, after issuing the notice to all concerned parties, including the earlier acting aim, shall pass appropriate orders.
Well, till the completion of the
appropriate orders, it's expected that the inquiry shall be completed expeditiously, preferably within a period of 2 months from the date of this order. like as ordered above, matter stands disposed of.
Let the matter be stayed, my lord, for the impute order.
They will be breaking of heads.
Yes.
Remember that, Sasi. Who has to consider that? What happened on the ground? They start breaking each other's head. Those who support you and those who are against you.
Second call.
Hello,
Item 6.
Dr. Muzika, why no compliance?
Well, I'll file an affidavit, well, because they're saying they're in the process of compliance. Well, the government 2 weeks time. Well, what is
Dr. Muzika today has expressed his helplessness and praised that he may be able to file an affidavit as a speech of compliance is taking time. Only 1 week's time is granted.
2 weeks.
Maybe 2 weeks.
My lord, it should not be like that. Operation was successful, patient died, my lord.
What I've been informed that he served only for 3 years. He's claiming 43 lakh rupees.
43 lakh rupees?
He served only for 3 years.
My lord, that's judgment is there, my lord. That they could have filed an appeal, my lord, if they had. My lord.
Hearing. 19.
This matter was heard in length, my lord, and my learned senior has apprised this honorable court that whether it is furnishing the documents in the DP is an empty jacket formula or not, my lord. She has some judgment, she was relying on those judgments, she was
Your
supposed
Lordship,
to
in this case, Your Lordship, the petitioner was the branch man. I'll just take Your Lordship briefly to the background of the case.
I've forgotten everything. This first time
Yes.
come after vacations.
Yes.
Yes.
So if, my lord, I need to submit, because I'm the petitioner, my lord,
Then you can submit.
then let it come up on Monday, my lord, I will submit. Because I was thinking, my lord, senior will place
Your
the
Lordship, in
judgments on
this case, Your Lordship,
You can't remember the fact, expect the court to remember.
No, I'm not, it's not that I don't remember, my lord.
no, we have admitted, Your Lordship, that the inquiry report was not furnished to the
Yes. And then
charged
my-
officer.
Then it has
Now,
fallen from my
and
lord.
then, Your Lordship,
Now the inquiry report was not given also.
no, it has not been given, Your Lordship.
So
Your
there's a clear
Lordship,
violation of principles of national justice.
Yes, that was my ground, my lord.
Yeah.
So my learned
However,
senior
Your Lordship-
has argued on this point that
inquiry report was unnecessary.
Was not necessary, and she has some judgment. She will rely on the
no,
judgment.
I mean,
so I was
we
on
have
this
not,
pretext, my lord.
we had to establish prejudice, Your Lordship, since non-furnishing of
You have to
the-
establish prejudice.
Yes.
If prejudice has been caused,
Because
then
they have
you
to establish
you have
that, Your
to.
Lordship.
And if he has
I will
been
have to
removed,
give them
was
the-
he removed on the basis of inquiry?
Dismissal. He was dismissed from service, Your Lordship.
That
Now, Your
itself, my
How
Lordship,
will not prejudice him?
That itself, my lord.
no, Your
was-
Lordship, what is the thing is this, Your Lordship, there has been serious misconduct, Your Lordship. He was the holder of the vault key along with the assistant of the bank. Now, Your Lordship, in the vault register and the bank balance cash register, it was shown that they had 18 lakhs in the vault. Whereas on inspection, Your Lordship, these are periodical inspections that are held. It was found that there was only 8 lakhs in the vault, but the cash register has been initialed by both the assistant and the branch manager, showing that there is 18 lakhs. Every day they have to initial the thing and showing that 18. Now, Your Lordship, it was found that there was a shortage of 10 lakhs rupees from the vault, Your Lordship. Then he claims that he did not know anything about it, although he has signed on the cash register, Your Lordship. So an inquiry was held, Your Lordship.
What happened to the other person?
The
other
accountant
person has been dismissed from
an
service,
accountant has
Your Lordship.
admitted, and even in the trial court, my lord.
He admitted that he took the money.
Yes, he admitted, and he has even deposed before this inquiry.
But
my lord.
his admission, but Your Lordship, the branch manager's involvement is also very serious, Lordship.
Sometime,
The
my lord-
misconduct
Of
is
course it's serious,
obvious.
yes.
Your Lordship,
Because
even
he is responsible.
Your Lordship, yes, Your Lordship, negligence, and it is his duty to look after
But
the
it was
interest of the
established that
bank
the 10 lakhs was missing.
Yes, Your
under the
Lordship.
watch of the petitioner and the accountant.
and the thing,
Yes.
Your Lordship.
Okay, you'll have it.
Monday,
Not on Monday, Your Lordship. Monday, I have so many other matters, Your Lordship, in the
We'll do it
lower.
on Tuesday. We'll do it on Tuesday, man.
Perhaps.
Have it on 17th. So this court won't be there from 11th to
My lord.
the rest of the week, yes.
My lord.
I'll pray of the
Right, Your Lordship.
this on 17th. 17th, for further hearing. Yes.
21.
May I please, Your Lordship? Your Lordship, this is a Nokma matter, Your Lordship. In this matter, Your Lordship had directed for translation of the Annexure 5 to the affidavit filed by the private respondent, Your Lordship.
Well,
This
it's
order
already.
Lordship, it is on 24/11/2025. There is an order.
My lord has directed, there was a dispute, my lord, on a translation of a particular document.
Yes, Your Lordship.
Then my lord has passed a direction to the translator to translate the document. On the last occasion, my lord, he failed to translate.
Oh yes. Have you got copies of this?
No, my
Your
lord.
Lordship.
You take copies as directed by this court by order dated
24/11/2025, my lord.
11/25, the copy of the spot inquiry. A copy of the letter dated.
The order.
The order.
No, this is the Annexure 5 of.
Annexure 5.
What is it? An order or is it a letter?
It's a inquiry report, Your Lordship.
The Magenta report.
A copy of the copy of the report has since been translated and has been placed on the record. Parties are permitted to obtain copies of the same from registry. Just after
2 weeks, Your Lordship.
2 weeks, yes.
Much less Lordship.
22.
May I please, Your Lordship, I'm praying for some accommodation in this matter, Your Lordship. I'm seeking for accommodation, Your Lordship.
What's the matter about?
It's a boundaries dispute,
Election?
Your Lordship. Boundaries dispute.
Who's leading in the case?
Mr. Sen, Your Lordship.
SN?
Yes, Your Lordship.
Yes, Mr. Dino. Yes, sir. Sorry, your name?
Estar, Your Lordship.
Oh, yes, at the request of MS Star. This is a matter of 2 weeks. 2 weeks.
Your Lordship, interim may continues, Your Lordship.
Mr. Marpan, your bank is. Why are you freezing all the accounts? Some amounts transmitted and then the whole account frozen. You even 2,000 rupees deposited to somebody's account of lakhs is frozen.
Okay, well,
Why? There must be some policy in the bank. It's only HDFC which is having this issue.
Okay.
Some internal mechanisms are there to to address these kind of issues.
We'll have to look at it. We receive that.
Otherwise, all will have to withdraw the accounts from HDFC. Whoever has accounts, me included.
Your Lordship, interim may continues in this matter.
Yes.
So we'll have a look.
24.
Well, exactly.
Yes.
Let you.
Lordship, I'm praying if
Yes,
this matter can be taken up next week, Lordship.
After at the end of the board.
Next week, Lordship.
Why?
Praying, Lordship, I need to prepare.
What's the matter about? Is that application now?
This matter is regarding that repairing of leakage and seepage in Nepal, Lordship. Wherein, Lordship, I have completed the contract, Lordship, and thereafter, Lordship,
All
sanction.
pleadings are complete.
Lordship, pleadings complete, Lordship.
Then you argue it. What is there?
Lordship, next week, Lordship, I'm praying here. Today, Lordship, some difficulty. Lordship. In fact, Lordship has passed an order, Lordship, if I may take your Lordship to order dated 21/7/25. Lordship.
You're going to have mediation also, it didn't work.
Lordship, mediation failed. In fact, Lordship, the officer who had come for the mediation, Lordship, was of the opinion that if any order flows from this honorable court, they will be willing to pay, Lordship. But they, on their own volition, they cannot pay the entire amount, Lordship. That was their stance before the mediation, Lordship.
Oh yes, this is arbitrary withholding of payments.
Lordship.
What is the amount?
26 lakh, Lordship, including GST, Lordship.
You can't resolve it.
But our case is that
The thing is that if he has completed the works in terms of the tender,
my lord, matter otherwise can be disposed of. Lordship, kindly seize my affidavit, my lord. Page 10 of my affidavit. Para 12.
your respondent number.
We are the only responsible.
Okay.
Case 10, para 12. my lord.
Page 10.
Yes.
Para.
Para 12. The last sentence, my lord. The respondent do not admit the amount inasmuch there is a categorical finding of the board of officers in their report dated 3/11/23 that the contractor has not done work amounting to 7.8 lakh along with some other rectification works. Now, my lord, the total bill submitted by them is 26 lakh. Your lordship, we find that at also find that at 26 lakh at page 4, my lord.
Of the affidavit?
Yes, my lord. Page 2, my lord, in fact. Same affidavit, no? Page 2, subpara A. Contract value was 26 lakh 21,000, my lord. And lords, you will see subpara E. E, my lord.
Yes.
So that is the amount of 26 lakh 21,000 and disputed amount is 7.8 lakh rupees, my lord. So let's see what I can submit, my lord. 7 minus 7.8 lakh that they can hesitate before the competent forum, my lord.
My lord,
the matter can be disposed of with the direction to pay this amount, my lord.
This is against their own admission, lordship. In my repetition, lordship, I have annexed that, lordship, after due completion, lordship, sanction was issued, lordship. Both proceedings, they themselves said that work has been completed satisfactorily, and thereafter order was issued for clearing, lordship. Then
nobody he's referred to 12. Now it says that the respondent admit amount as much as categorical finding.
This is, lordship, only after the
report.
This is, lordship, they have said, lordship, only after the institution of the writ petition, lordship.
When was the writ petition filed?
Lordship. January, lordship. 2025.
No, report is 3/11.
3/11. That is at page 35.
Before the writ petition. Then.
But lordship,
you don't have application
lordship, but the admitted fact is that, lordship, after the completion of the work, lordship, they themselves, lordship, after due inspection, they have issued the.
But some officers, how it happened, my lord. Some officers sanctioned the amount, my lord.
Sanctioned the?
Approved the bill and sanctioned the amount, my lord, at one point of time. But later on, when further investigation was done, the matter was inquired into and board was constituted. It turns out that they have not completed the 7.8 lakh.
Not only that, lordship, after when they gave us a letter for rectification, lordship, we had on 2 occasions, lordship, carried out this rectification work, lordship.
So are those bill additional works or a part of the contract?
Part of the contract, lordship, because they were not satisfied. So in order to, lordship,
inspection, what you making, what building?
Not, lordship, not building, lordship. This is only, lordship, repair work, lordship. Rooftop repair work, lordship, ancillary works.
Contract was 26 lakh, my lord. He completed the work according to him. And he submitted the bill. So some officers, my lord, they sanctioned the bill at that point of time. Later on, we realized, my lord, that the work has not been completed. There are several complaints from the residents whose houses were repaired.
And one important aspect is that the inspection that was carried out, lordship, later on, it was done at their own behest, lordship. I was not a part. I was not given an opportunity to be a part of that inquiry, lordship. How can I ascertain, lordship, that these are the amount, lordship, that is.
The writ petition, my lord, these are.
Very difficult.
Very difficult, my lord. I'm not asking lordship to foreclose them. They can hesitate that one.
You take the other amount, not bringing 1 rupee or so till now.
Lordship?
1 rupee.
No, lordship. We have not received 1
rupee.
Then.
By lordship,
whatever amount.
What I propose that let there be direction by lordship to pay the amount, disputed amount. They can hesitate before any other.
Lordship, that in that case, lordship may have it day after tomorrow or Monday, lordship. We will have instructions taken.
Yeah, tomorrow would be Saturday, I think.
Yeah. Monday, lordship, in that case, lordship.
Okay, Monday. In the course of hearing, it is seen that though the contract amount is of rupees
26 lakh
21,000, lordship.
21,000. The amount in dispute is only of 7.89 lakhs. The court of the view that perhaps the undisputed amount be released to the writ petitioner, in the meanwhile leaving with liberty to leaving the rest the undisputed amount to be agitated further by the writ petitioner. And Ms. Estanda prays and obtain instructions. This is the matter on Monday. Yeah.
25.
Yes.
May it please your lordship. My lord, petitioner before your lordship is a retired professor of the Nehu University, my lord. Here, my lord, this writ petition was preferred, seeking, my lord, that interim amount, my lord, the period when he was under suspension, my lord, the arrears. My lord, basically on two grounds, my lord, I can understand, my lord.
When was the sentence here?
Yes, Your Lordship. Your Lordship, hearing has been concluded in this matter, Your Lordship.
Concluded?
Yes, Your Lordship. Your Lordship, may check order dated 6/10/2025. Your Lordship, it's for the petitioner to come with authorities, Your Lordship.
We'll do it, my lord, shortly, my lord, within some time. I am ready today for today, my lord.
With authorities?
Authorities, otherwise, my lord, we have seen, my lord, that we are on to the, my lord, what the statute says, my lord. Only two point, my lord, I will just put before your lordship that.
1 second.
Yes, my lord, 2 points were raised before this honorable court.
Only for the increment now?
Increment and the, my lord, the
raise of salary.
Yes, raised of the salary. My lord, here only on two counts, my lord, I am before your lordship. Number one is this, my lord. There was a complaint by one lady, my lord, and in the criminal case that was although withdrawn, my lord, the statement was recorded by the learned magistrate below. She has submitted whatever she has to say. It is not a pure case of joint affidavit that sort, my lord. It was heard by the court below. The statement of the victim was recorded, my lord, released victim. And thereafter, my lord, since both the section 506, 509 are compoundable, she said, I am not, it is not that we have compounded together or made a compromise, but as she is in research duty, my lord, she is not able to come again and again to the court, so she is not pursuing the cases. So this amounts to equital, my lord knows, my lord, 328 subsection 8, my lord. It says whenever honorable court come into a conclusion that it is compounded, it amounts to equital, my lord. That is 1 point, my lord. And a second limb of my argument is this, my lord.
Yes.
Yes, the contents of my learned friend on the other side, my lord, they say, my lord, since I was not in duty, so no work, no pay. That is their contention, my lord. But my lord will kindly see, we have approached before this honorable court at page 27, my lord. This honorable court instated my suspension, my lord. And at page 27 by this honorable court, my lord.
It's under rule 10(6).
Yes.
That's a different matter.
Yes, my lord. And thereafter, my lord, lordship, that most importantly, it is on page 43. My lord, here the proceeding ended without any penalty or any guilty, findings of guilty of myself, my lord. It has been closed. That amounts to, my lord, my to be clean from the particular proceeding, my lord, departmental proceeding. Because I was not found
guilty. There was no finding, the sexual harassment is no finding.
No, my lord, no. It said that it is closed.
This so is internal inquiry by the IQ, by the, yes, Mr. Sen, is by the, this 44.
Yes, page 44.
So you close the case. That means nothing. Like there's nothing.
No, inquiry was closed. That's a fact, my lord.
Then
only thing, your lordship, there's serious charges against him. He has been placed under suspension, and the suspension ultimately revoked, my lord, because of an order passed by this honorable courts.
It's a technical fault regarding 10(6). You have not reviewed the suspension of 90 days. Correct.
Right. Yeah. Now, my lord. Thereafter, my lord, just give me the affidavit. In our affidavit, your lordship, my lord, you should take up our affidavit, your lordship.
B2 letters.
The last page, man. Resolution number 2 of the EC. Lordship has got it, my lord. The last resolution. Follow-up action of the Minus meeting of the Executive Council relating to Professor Srivastav Department to treat the period under suspension as period in service for grant of such and such. The Council was apprised that the Executive Council 187th meeting held on such and such, they resolved that status quo be maintained and further resolved that the legal officer by order dated such and such has submitted the comment. The comment of the legal officer was read out before the Council. The Council deliberated on the matter. The Council resolved to regret the request of Professor Srivastav to treat
what was the comment?
My lord, that Lordship has asked for it and I have placed it, the records.
It's here in the record?
Yes, my should be in the records.
You have seen a copy of that also?
Yes. No, my lord.
I've given them a
yes.
copy.
Yes.
Where is that?
The order, no?
To read from where? There are two opinions, madam.
Which is the legal opinion? This is, just see from here.
2 pages, madam. 2 opinions are there.
Which one?
This is the first.
No, the relevant one.
Is this
26 June. The legal opinion was on 26 June.
This is
26. This one. Peruse the notes.
Three 328. IPC on 9. Oh. My lord. Did.
He submitted the details of the compounding order. What happened after that? This is only opinion.
After that, the last one, Your Lordship.
Yes.
Second opinion, I have flag marked.
Second petition.
What is the first one only? That's
First and
shown.
second.
Second one's earlier. Later, I'm sorry.
These are the two opinions.
He didn't submit the documents that are requested.
Submitted, my lord. Submitted.
Then it's
And this this particular order, my lord, was on shown to be on my day of supernation. My lord, I was very much present, but I was not given an opportunity. And this order, my lord, we have come to know from this honorable proceeding, my lord. Here, my lord, if lordship allow me, only 2 counts, my lord. This particular order, my lord, that opinion, my lord, both the opinion are misconstrued. I'll tell why, my lord. Number 1, acquittal as such, my lord, cannot be said that on merit or there is no difference as such, my lord. Acquittal is acquittal. Once I am acquitted, after hearing the parties, my lord, it is not that a joint affidavit filed and it is withdrawn. Her statement was recorded and thereafter the learned court below.
Where authorities?
My lord.
Where authorities?
Authorities as such, my lord, this law is clear, my lord, that is why I am just, it says, my lord, at page 8, with that paragraph 8, my lord, the composition of an offence under this
From where?
is 320, my lord, 320. Offence to be compounded. There, the thing is, the composition of an offence under this section shall have the effect of an acquittal of the accused with whom the offence has been compounded. Very clear, my lord. My lord, once I am acquitted and therefore the proceedings has been closed, there is nothing on record to show that I have been found guilty or any penalty has been imposed. So, my lord, my learned senior friend has also on that opinion itself, my lord, FR 54, it says, my lord, provided that when a government servant who has been suspended is reinstated, the authority competent to order reinstatement shall consider and make a specific order regarding the pay and allowances to be paid in the to the government servant for the period of suspension, and in the second, my lord, whether or not the said period shall be treated as a period spent on duty.
Yes.
So, my lord, it is very clear, my lord. I have to be considered to be on duty, my lord, and no work, no pay will not come here. And, my lord, it is admitted position, my lord. I have been working long in the said university, my lord. Something have creeped up, my lord. That is true, but against me, my lord, there has been nothing against my that career as a professor, my lord. I have retired as a head of the, and my lord, all throughout these days, my lord, this is something, my lord, very unfortunate, my lord, but in my career, and now, my lord, I have my family out of court, my lord.
When did he retire?
He retired in the year 2023. 30 June 2023. While off the record, my lord, I should not, but he has his sons and daughters who are studying, my lord. They are in hardship, my lord.
Why hardship?
My lord, because they are studying, my lord, for finance and all links. My lord. This not very big amount, my lord, but this will be very helpful, my lord. A substantial help, my lord, that way. And I have been acquitted, my lord, and closed also. Nothing. Both the courts has court and the proceeding, my lord. Nothing.
Yes, Mr. Sen.
Yes, my lord.
So you think you don't need any.
Lordship will look into, my lord.
You're only relying on the definition of section 320.
Yes, 320, as well as, my lord, 54 of the FR, fundamental rules.
No, I will rely on 54B3, your lordship. This is in the legal opinion.
Yes, I am relying on 54B. FR 54B.
My lord.
Yes.
And, my lord, 320 of the CRPC. Which says, my lord, acquittal is acquittal, my lord.
FR4B.
FR4B. 54B.
Sorry,
54B, my lord. It says, my lord, if reinstated, that period will be counted as I am in work.
Yes, Mr.
Yes, my lord. If your lordship look into this legal opinion, my lord, 54B3 has been quoted.
In the first legal opinion,
my lord. B3.
Yes.
I just where the authority competent to order instance of the opinion the suspension was wholly unjustified. The government servant shall subject to the provision to be paid the full pay allowances, etc. So, my lord, even if reinstatement order is passed, your lordship, it is for the competent authority, my lord, to come to a decision whether the suspension was unjustified. That means whether suspension is otherwise justified, my lord. Now, lordship, here is a case, my lord, a research scholar lodged a complaint of sexual harassment, and lordship is fully aware about, my lord, the consequences in the Harassment Act and all, my lord. This call for a suspension. My lord. So, my lord, it is not a case, my lord, that the suspension was unjustified, my lord. Suspension was fully justified, my lord, when the nature of allegation was this. So, he was placed under suspensions. So, my lord, when subsequently, my lord, after compounding of the offence, my lord, and we also closed the inquiry otherwise, my lord, he filed a representation, my lord, seeking that this period should be treated on duty. We looked into all these aspects relevant law, your lordship, and passed the order, my lord, regretting his request for treating the period on duty. So, my lord, whether the suspension is justified or not, that will depend, even in this situation also, when the inquiry is closed. It will depend on the, my lord, decision
now you
of the...
say that to decide this, whether it's justified or not, is totally in the hands of the counsel.
Reinstating.
He holds the 320 anything.
Reinstating.
He's been acquitted. Yes. Now, acquittal cannot be two types. He's been acquitted and compounded, so it amounts to acquittal. Correct. So you can't say acquittal was right or wrong, or there was any fine out of the court. That is a thing that you can't enter. Now, your second submission is that you have the authority to decide whether suspension was justified or unjustified.
Only suspension.
Now you say that suspension was justified due to the seized allegation, but in the proceeding nothing has transpired. So how?
In the criminal proceeding, nothing.
How?
So for the
you closed the internal complaints also, you closed it. Internal complaints could have gone on even if the...
No, that's true. That's true. We have closed it. But we closed it. My lord, university has closed. But only thing is whether the suspension is justified, my lord, that is on the authority, my lord, who can order reinstatement. Now the university, my lord, competent authority is the EC. Now EC, after proper deliberation, they came to a finding, my lord, that they will not treat the period as on duty. Because they found, my lord, under the circumstances when the order was passed, it was fully justified. Of course, it was justified, my lord, when this kind of allegation comes against the teachers. We are not expected, my lord, that we will allow him to continue, my lord, without taking appropriate actions. So this is the...
So rationale behind this, rationale behind the sub-rule 3 is based that during the period, what opinion was generated? That's all. There's only opinion generated based on legal opinion.
And this is an order passed by the EC, your lordships, after deliberation. So that's my submission here. This is the reason
my lord,
I found it justified.
I am just
reply.
Yeah.
Yes.
My lord, if my lord knows, my lord, suspension, promotion, these are temporary things, my lord. In a proceeding, my lord, a departmental proceeding, final outcome is to be taken care of. When, my lord, they say we are closing it,
that means only form
yes,
an
yes,
opinion.
my lord.
You only form an opinion that is
Yes,
the reason.
suspension is, my lord, for a temporary
Now
period.
whether you can segregate that, you close the case and still form an opinion as justified suspension. How?
Opinion, my lord. Opinion, I am.
How can they come to an opinion that's justified if they close the case? If they find that the suspension is justified, they should have carried on with the internal complaints.
Yes, and they could have given, my lord, other than closing also, they could have definitely
some findings.
Yes, yes, my lord. That is where I am.
Lordship,
If the initial the ab initio, my lord, that thing is if found to be wrong in the later part or not to be correct, that part goes, my lord, because suspension is a temporary part in the whole proceeding.
Lordship will kindly see the language of 55, even in case of reinstatement, where the, my lord, inquiry led to nothing. Even in that case, that 54(v)(3, whether the competent to order reinstatement is of the opinion that the suspension was wholly unjustified. Only then, even if there is a reinstatement ultimately, nothing proved against the delinquent, but even then it will depend on the authority, my lord, to take a call.
No, but what submitting is that there has to be some finding.
Yes.
If the executive counsel also that.
Of course, admittedly, my lord, that inquiry was closed. That's I cannot deny.
No, you say that yes, notwithstanding anything else, closure of the inquiry or the acquittal from the criminal proceedings, the suspension is justified due to the seriousness of the allegations. Then they would have.
True, my lord.
Yes. What is the amount?
Amount is, my lord, we have found out around 12 lakhs.
That we have denied, my lord.
My lord, we will leave up upon the concerned university, my lord. Whatever is, my lord, entitled, my lord, we will be happy, my lord.
Yes.
We have calculated it to be around, my lord, 12 lakhs 7,000.
12 lakhs?
12 lakhs.
That's not correct.
Anyway, my lord, we have therefore.
How long we suspended for?
Suspended for around 120 days in here, and this is suspension time to. From my lord, 8/11/2017 to 15/3/2019. For
8/11/2017.
Yes.
November 17 to.
November 17 to March 2019.
There you go. No, ticket for okay. We'll pass orders then.
Yes, yes. I'm deeply obliged, my lord.
Obliged.
You can't quote any more time.
But so far the amount we disputed. Seriously.
We'll not talk about any amount.
27.
You don't be entitled to arrears and the increments, whatever due.
May it please your lordships. Lordships, we filed our rejoinder affidavit, lordship, on the last date.
This is regarding that claim for
reservation.
But then,
lordship.
where's
Lordship is on legs.
Lordship, our grievance here is very limited, lordship.
Yes. The affidavit of opposition. This. What to do then?
Lordships may have it after 2 weeks, lordship.
You're paying UGC?
Yes, lordship.
What do you have to say?
Lordship, they're just formal party, lordship.
No instructions necessary here?
No, your lordship. Unless I'm quite in this on record.
You only EWS.
Lordships.
The only AWS don't have. I don't think, but central government has come out with a policy also for.
Lordships, it's been 11 years, Lordships. There has not been any creation or.
Come out with any policy, I think, in any
Lordships, no.
central government organization.
No, Lordships. Despite the constitutional obligations that have been crystallized by the Supreme Court, Lordship, in the NALSA 2014 judgment.
Yes. But then on the ground, it's been implemented with regard to toilets and with regard to separate cells. Holding cells for LGBT persons, even Shillong jail also.
Lordships.
Are you involved with legal aid?
Yes, Lordship. This is a legal aid matter, Lordship.
Yes. You have the brief with you?
Yes.
You will have it after 1 week then.
Lordships.
Yes. You have the brief with you also?
Yes, Lordship.
Okay. This on the request of MS C. Jala due to the absence of a senior. This matter after 1 week is
Highly obliged.
Highly obliged.
Any mention? Item number 1.
Made, please, Your Lordship.
You file a fresh copy
My lord, I have filed a corrected copy of the report.
today itself.
No, my lord, the next day. The next day when the order was passed, my lord. On the 3rd, my lord.
Your Lordship has seen the entire report, my lord. And only discrepancy Your Lordship has noticed when I was showing the photographs and annexes, my lord, of the pages, my lord. Your Lordship kindly come to page 83, my lord.
Of the status report.
Yes, my previous the status report filed on 27 January, corrected copy, my lord.
One second. Page 83.
Yes, my lord. Now, I was showing photographs of demolition of various coke oven plants, my lord. At that stage, your lordship found that the court's copy was not telling with my copy, my lord. So now, my learned colleague has filed the corrected copies, my lord. And these photographs are showing that we have demolished all chimneys, my lord.
Section 9.
Yes, my lord. Annexure 9, which starts from page 83, my lord. And then there was one more issue which your lordship has posed regarding the quantity of coal left to be auctioned, my lord. That was
So
the
there are two
issue, my
types
lord.
of coal: seized coal and the inventoried
Yes,
and
my lord. Yes, my lord.
inventoried and
Yes, my lord.
yes. What is that? What
Yes,
do you
my lord.
say?
The data which I showed, my lord, to your lordship at page 18 on last date of storage.
1/8.
1/8, my lord. And 1/8 last column, your lordship will find 152,715 quantity left to be auctioned. And seized coal is, your lordship has seen the bottom of the map. Bottom seized coal, name. Yeah, seized coal is under the section 21 of MMDR Act, and this inventorized coal is in the table ever of seized coal.
So just come. Where's seized coal? Where's written seized coal?
We also will see after the table in the middle of the
the next day, the next one. I thought you were mentioning to the same pithead report. Coal transported inventory.
Page 18. Yes.
Yes, yes.
So
The next caption is seized coal here.
Yes, ma'am.
Yes.
So that is what we get it from.
It's only from one. There's only one depot.
Yes, my lord. So wherever there are various FIRs registered.
No.
Various
seized coal. What this coal wants to know is how much seized coal is there? How much been auctioned? Seized coal till now.
I'll place that. I'll get the instruction on precise how much seized coal and which police station where it is pending, my lord. I will give the entire data on
that. Also, I think we require that data with regard to how much. You see, we want to see whether seized coal is being auctioned faster than the inventoried coal.
Yes,
so that's because the thing inventoried coal is not moving at all. Then why is
yes,
and I think see quantity sold of this pithead to depot coal is only 11,000, 1,15,000. This is only East Jayant Hills, correct?
My lord, this is yes from the this is East Jayantia Hill. Yes, my lord. This is the East Jayantia Hill, and if your lordship will see the previous page at page 16 bottom left.
Yes.
16 bottom is the coal which was put to auction by MSTC, my lord, and total quantity of coal which was put to auction was 2,99,993, out of which 51,685 metric ton of coal could be auctioned, my lord.
Who's appearing for Coal India? Yes. Mr. Datta, where's Mr. Ahmed? He's still indisposed.
He was not well. He was not well on that first date of hearing.
Now, who maintains records of, the exact coal sold so far from this re-ventrate, this transported re-ventrate coal, and
that is
coal
maintained by the state government, my lord. So far,
then we would like details of that. We just have to have a overall picture. Yes, from Coal India also.
Yes,
depots, this is MSCC depot also, right?
Yes, my lord.
Yes. Yes.
And then there is a new report which has come up, my lord. That report has to be given to us for our comments and observations.
Yes.
Justice Kataki has filed.
Yes. Before that, we'll address this thing. Just take down. Judge's report on behalf of the state respondent to the interim report to the 34th interim report, correct? 34th interim report of the Justice BP Kotoki, retired committee, have been filed. Stop. Salient features of the status is with regard to the initiation and process of auction of reassess / re-verified coal by Coal India Limited. But this is only STC. What is about by the Coal India? This report at Annexure 1 is only by the Mineral State Trading Corporation. Yes, you are muted.
My lord, we give this data, the entire coal to the Coal India for auction, my lord.
And MSCC works on the Coal India?
Yes, MSTC is the limb of Coal India. And
no. In this case, auction. Only MSCC. What about, you see, the thing is that what we want to understand now is also these CI designated depots, they also, like you showed page 83 or page 18, it goes, it is in the depot of Hopeful Bowman. See, this is
these are the depots established by state government, and these persons are licensed to maintain depot, for which they maintain and take certain charges.
Right.
That is
now only and for the other coal it goes to this to CIL, the related depots, correct? Or are they same depots?
They are the same depots, my lord, because we have got depots, various depots.
Now if the same depots, that means this re-inventory, reassess coal gets mixed up with the seized coal.
No, my lord, seized coal is a separate.
That's what the court is saying. It will be a separate depot for seized coal at different quantities.
Yes, my lord.
And for the reassess, re-verified, re-inventory coal be different.
Clear instruction on this issue. How much seized coal, where those coals are lying, and whether there is any mixing, etc. or not.
We just hope that
those seized coal.
Yes. Yes, sir.
I'll place the material on that.
For auction, reaction. Auction. By CIL. And also has reported with regard to the discrepancy which was discrepancy was discrepancy
that 5.5 million.
5.55 point.
Yeah. 4 million. Because
and
of the
And on the report is, and the variation figures has been attributed to the fact that the same has arisen on account of reliance on two separate auction reference dates and not on account of any physical shortage. Stop. A letter of the DMR dated 9/1/2025 has been annexed to substantiate this fact. Where's the letter? Oh, here. Yes, yes, 17 is.
17.
Yes. Next paragraph. With regard to the illegal mining site at Krem Langsat, KREMLANGSHIT Forest, Lumbangla Village, East Janta Hills. Action taken has been detailed in the report, and the same comprise of dismantling of machinery, destruction of makeshift camps, and the barricading of the mining site. CJ memo has also been provided in the said status report. Stop. Further, the report has elaborated that the steps taken by the Deputy Commissioner on instructions from under directions from the committee pursuant to meeting held on 16/1/2026, and the minutes of the 11/25 and directions on 25. Yes. Thomas. The steps committee was a meeting held on 11/12/2025, and a copy of the minutes dated 11/12/25 also been annexed in the status report, which amongst others have directed for the deputation of executive magistrates jurisdiction wise, jurisdiction wise, who are to coordinate with respective officer charges, officials of mining department, to conduct surprise checks / inspections on vulnerable pockets to detect any instance of illegal mining activity, to submit monthly reports, and to undertake drone-based monitoring in hard and inaccessible areas, with the same to be attached to the said monthly reports. Stop. It's also been stated that directions have been issued for a monthly review meeting with all the concerned officials and for gathering of actionable inputs from ground and to coordinate with local headmen for detection of legal mining. Stop. Next paragraph. It's also been reported that in compliance, it's also been reported that in compliance with directions of the committee, recommendation of the committee, steps are being taken for identification of vulnerable areas and the preventive measures to be taken. So, it's also report the process of reaching out to coal dumps found during the aerial survey by Messrs. M. Garuda in southwest Khasi Hills has also been conducted, and it is reported that coal was found in only one location of around 5.6 metric tons, empty, M capital T capital, as compared to 6.38 MT said to be detected, and that in the remaining 27 locations no coal was found. So, with regard to East Janta Hills, it is reported that physical verification in respect of 1572 dumps as recorded by Messrs. Garuda have been undertaken. And it is reported that though the quantity of coal as per MS Garuda is 180 1, 80, 299, 48 MT. The quantity detected as per physical verification is 1, 43, 939 MT, which it is submitted which the discrepancy the discrepancy is sought to be attributed to misdetection or misinterpretation of digital data.
Page 74, my lord.
Annexure 7.
Yes, my lord.
A summary of a letter addressed to the Commissioner by the Divisional Mining Officer dated 9 January 2026 of a summary on physical cross verification on missing coal has been submitted to this effect. Stop. The said letter also indicates the filing of FIRs on missing coal of various quantities. Stop. Next one. Nothing. As far as West Khasiel district is concerned, it is reported that physical verification has been completed and the process of shifting the said seized coal to designated depots would soon commence. In respect of Southwest Khasiels, it is reported that the district administration has sought permission for shifting of 3,039.92 MT, 3039.92 of seized coal from Rajaju and Dingan villages to the demarcated CIL designated depot, and that investigation of missing coal is being actively pursued. Now, all have been demolished, right? All illegal coal plants.
Yes, my lord. All demolished. All demolished.
Next paragraph.
All demolished.
It has also been reported, and also, along with copies of completion inspection reports, that all 33, they are 17 and 20 and 11, only 28, but the Supreme Court said 33, correct? You're muted.
Sorry, Supreme Court said, if I remember correctly, my lord, that those who are having, they can. No,
the number to be demolished. The number to be demolished.
76. Because I get the figure, my lord. I will check the figure also, my lord. I will come back with the correct figure. But what I figure I see at page 76.
So Supreme Court said how many? See.
That I have to check, my lord, and I'll find out the instruction on that issue, my lord. I'll take instruction on that point. But as per report, they say that entire all coal chimneys have been.
An inspection report for West Khas Hills and East Janta Hills that 17 illegal coal plants have been demolished in East West Khas Hills and 11 in East Janta Hills. Stop. The Advocate General, however, has prayed that be allowed to obtain specific information with regard to as to whether there are any other illegal coke plants that are yet to be demolished. So, next paragraph. On other matters, it is reported that recovery proceedings have been pursued against defaulting coke oven plants and Russell units, resulting recovery of 1 crore 50 lakhs 18,857 only. 15018,857. And that enforcement action has been taken in accordance with the recommendation of the committee. The report also touched upon the steps taken for mobilization of funds deposited with the Central Pollution Control Board for formulation of livelihood schemes, the process for recovery of demurrage charges, and also the fact that the draft report for restoration of mining areas has been filed.
Yes, my lord, if your lordship will see.
But is not included in the report, in this report.
Yes, my lord. Yes, my lord.
Yes.
Paragraph 15.1.
Problem? And the formulation for recovery. Yes. To be paid by successful bidders and that a draft report for mine closure and restoration of mining affected areas for plot sites for pilot sites, yes. Yes, at East Janta Hills and South Garo Hills has been submitted for technical review by the Directorate of Mineral Resources. Stop. From approved status report, it is next paragraph. It is also seen that data has been provided with regard to where's that seize code and that reassess, re-verify that one annexure page?
Page 18, page 18, Your Lordship. You'll find page 18. Page 18.
That at page 18, bracket annexure 1 thereof.
Yes.
What is it called? A summary of completion of court transportation from pit head to depot, PITHEAD, to depot, DEPOT. With the quantity sold and quantity left to be auctioned. Was also seized coal put up for auction in one depot has been furnished. Stop. However, this code, however, directs that state respondents furnish a detailed report with regard to obtaining the details from the CIL and from other sources and from district administration with regard to the total quantity left to be auctioned, which are lying depots, the quantity already sold, the quantity of seized coal put up for auction, and as to whether the seized coal is in any way being stocked together with the reassess, re-inventoried, stroke, re-verified coal, which have been transported to the CIL designated depots. Next paragraph. A 35th interim report has also been filed by the committee on 27/1/2026. And has flagged the issue that East Jayanta Hills district is the most affected district in the state of Meghalaya in terms of coal mining activities which have been held to be illegal by the NGT as well as by the Honorable Supreme Court. As well, they're being continued as well, there being large-scale continuance of illegal coal mining activities which have been reported from time to time. See, one thing, Mr. Arvind, is the death of that person from Assam. That
Yes, Lord.
see, there was a person who died in a coal mine. Correct? I think it had been. I'm just looking whether it's there in the 35th interim report. See, you remember that it came out in the news. This one person, yes.
Yes, I read in Sri Lanka, my lord. There was some news regarding death of a minor.
Yes. Very good.
Lord, kindly give me this report and then
Yes.
we will respond and we'll find out.
Yes, problem. In the said district. Stop. The interim reports also noted the incidence of accidents whereby persons have lost their lives while engaged in illegal coal mining, such as the incident that occurred on 14/01/2026 in Thangsko, Thang SKO, under Clearer Police Station, wherein Clearer PS case number 11/2026 been registered. Stop. The respondents as the recommendations are exhaustive in the 34th report, especially with regard to proactive steps to be taken to contain the continued spate of illegal mining, which this court finds distressing, shall file a detailed status report on this 35th interim report by can you file it within 4 weeks? Yes. Stop. No, it's a further remuneration. Yes, sir. It's also directed that a further remuneration of rupees 3 lakhs and other incidental secretarial costs be paid to Justice BP Kotuki. Yes, for the services. Just after 4 weeks. Copy of the 35th interim report to be supplied to the parties. Yes. Well, one thing, you need a more proactive. You cannot just have, firefighting. Like illegal mining is reported, but then in East Yantiel is happening with, it's just, it is a whole, if you look at it, it's a whole chain that's operating. It's not only a question of why would they engage illegal mining if it's not very, very lucrative.
I understand you.
And see, the thing is that the time has come, like if we get the second status report, it's just a preview of the orders that might come. is to hold, we will direct for the accountability of certain officers also who are supposed to check this. So we have to implement it, go proactive. We have to hold them personally responsible. So that we don't want that to come now. But the thing is that I think we will be compelled to pass orders whereby they'll be held personally accountable in the implementation, and if they fail, they will be accountable.
Yes, madam. Now, your lordship has seen that the joint, the minutes of meeting and direction of the committee clearly says that monthly report is to be prepared, drone survey is to be carried.
Yeah, that's very good, but you can't just you can't reduce the committee or the court to a paper tiger. That you can give directions, but on the ground nothing happens. Under the very noses of the police or under the administration, people are happily carting away the coal and selling it.
No, my lord, now because there is a direction now that has to.
You kindly file this report and we'll see. Yes.
Item number 2.
Yes.
Yes, madam.
Yes.
May it please, Lordship. Lordship, I pray that this matter may become up after 2 weeks as the conducting counsel is out of station.
You received a compilation. Where's Mr. Bhama? You was here just now. You received a compilation, 2 volumes. You received a compilation.
They have submitted.
What do you have to say?
Yes, my lordship, I have received the compilation.
Right. They'll fix it after 2 weeks. Yes, what do you want to say?
Yes, my lordship, it may be fixed.
Mr. Deb,
Yes, my lordship, the main matter was that the compilation report is there already, but after exhaustive 64 hearings on the matter and more than 27.
Forget about that exhaustive hearings. How many dates? What do you want? What do you want? You've got a copy of the compilation, filed 2 volumes, been served upon you. We'll consider the matter next date. Yes.
Yes.
Yes, sir. Mr. Bhama is present personally in person on behalf of respondent number 14. Appearing person is present personally. Stop. He submits that he has received the copy of the compilation, filed 2 volumes. Stop. Accordingly, it's a matter of 2 weeks for hearing.
3.
Connected with, yes.
Connected matter, madam.
Thank you.